My name is David Kamen. I'm Charles L. Dennison, professor of law here at the law school. And I'm excited to be joined by our panel today. So on our panel, we have several distinguished scholars, Jillian Metzger, the Harlan Fisk Stone Professor of Constitutional Law at Columbia Law School, Kent Barnett, the Dean and J. Gilbert Reese Chair in Contract Law at The Ohio State University, Sharon Block, Professor of Practice and Executive Director of the Center for Labor and a Just Economy at Harvard Law School, and Bijal Shah, Professor and Provost Faculty Fellow at Boston College School of Law. In this panel, I think we are hoping to explore the ways in which many of the developments that have been discussed today look different depending on where you sit. We will discuss the ways in which the doctrinal and other developments cut consistently toward a single ideological or substantive agenda or do not. The ways in which administrative law is a single body of doctrine or really separate bodies of doctrine dealing with different areas of law. We're going to start it off today with comments focusing on broader developments across administrative law from that perspective with Jillian and Kent, and we'll then wrap up our initial commentary with Sharon and Bijal focusing on specific areas, labor law and immigration law. So with that, Jillian, I'll turn it over to you to kick us off.
Thank you. Thank you very much, and thank you to the NYU Law Review and to the Center for Policy Integrity. It's been a great conference. I've really enjoyed the day. And my remarks are going to be pretty brief. I thought I would just talk a little bit about some of the political and ideological orientation underlying what we've seen in the Roberts Court's administrative law jurisprudence, and then riff a little on how that might affect how that jurisprudence can be used or developed by others. And there might be some affinity between Nick's statements in terms of connecting to some of the political developments and some of the themes of what I'll be talking about. So I think that, to orient my comments, I wanted to sort of take a step back and focus on the Roberts Court approach more generally to executive power. And in that category, I mean not just relevant administrative law decisions, that many of which have come up today already, but also ones that sound in broader separation of powers background, so presidential, congressional disputes, and so forth. And when you look at that body of decisions, I think you see that they really fall into two camps. There are decisions that address presidential power per se, and then there are decisions that just address administrative state and agencies. There is definitely overlap. There are some cases you can put in both categories, and there are also some shared dynamics. There is a strain of increasing judicial power that runs throughout both. But there's also a significant divergence between these two categories of cases that I think is worth noting. And in particular, I think the Roberts Court generally takes a very expansive view of presidential power and often pushes precedents in a very president empowering direction. Think Mazars versus Trump versus United States as a classic, Sela, and so on. But when it comes to administrative state, I think the Roberts Court generally moves in the opposite direction, often narrowing administrative authority, but particularly regulatory authority on constitutional and statutory grounds. I do want to really emphasize that these are general trends, and I think we're going to have discussion later about how these play out in particular areas. There's a piece that's, I think, forthcoming still in NYU Law Review talking about how, in fact, when you focus on immigration or you focus on criminal law enforcement or you focus on national security, the administrative state part is not so retracting of power and more expansive. So this is really more aimed at regulatory and benefits kinds of cases. There is this divide sort of between these two categories of cases, and I also think it's clear if you look at the cases, that divide doesn't really map some kind of analytic pre-commitment of the justices. So for example, in separation of powers land, you would often think about formalism and functionalism. One of the things that I think is interesting is that there are formalist and functionalist cases on both sides of this category. I think that many of the presidential decisions are actually pretty functionalist, and you have combined formalist features and functionalist features in some, like the Sala case, but it's not like you're talking about a formalist approach in administrative law and functionalist in the presidential area, because you also have very, very functionalist cases like the major questions doctrine that often is in the administrative state. So I think if you try and drill down and explain the divide here analytically in terms of those approaches, it doesn't really work. They're on both sides. I also think that there are actually arguments in some of these cases that are in tension with one another as well. So, and I think Jody Short and Judge Sugarman have made this point really well, that if you look at some of the decisions that I would put in the administrative state capacity that pull back on administrative capacity, they actually make it a lot harder for presidential political accountability to be realized. And so one of the main arguments we've seen coming out of the Roberts Court and some of the presidential's decisions is this idea of the president's the most politically accountable part of government. And if you really trace that out, I'm not sure that you would end up where you are on the administrative state cases. So I think there's some analytic tension between these two categories. So what is it that explains them? And honestly, what they map pretty well is conservative legal and political agendas. So there are obviously lots of varieties of American conservatism, but there is has been a theme for several decades of a conjoined commitment to unitary executive power and also to a limited national administrative state. It's interesting if you go back in time we were talking in the last panel a little bit about the New Deal period, and if you go back in time to that period, I don't think you saw that same conjoining. In fact, many of the people who sort of gave the most, I'm thinking about the Liberty League folks, but some of the folks who gave the most strongest constitutional attacks on the administrative state were also attacking FDR and the kind of expansive presidential power that he was wielding. You didn't see that same linkage. It's more with Reagan and the birth, I would say birth, of unitary executive theory much later in the 19th century. That's when you start to see that aspect coming more into the conservative legal view. It's also interesting that if you go back to the 20th century, you'll see the anti-administrativist line voiced by many liberals and folks on the left. And prime example here is Charles Reich and his new property and his view of the state as a siphon and an entity that seeks to exploit dependency. And obviously part of what he was responding to was the emergence of the national security state and the kind of dependence and vulnerability people were exposed to. So you certainly can see anti-administrative arguments that have not just a conservative valence, but that have also in the past had a liberal valence, even if we see them today and they've got, in the Roberts Court, more of a conservative edge. The reason to sort of pull these apart is if you're thinking now going forward, how these arguments can be used by different groups, or whether these different kinds of arguments might be appealing to different groups, figuring out whether or not you have to take along the expanded presidential power with the anti-administrative line is probably worth considering, because that would be a reason why it might be less appealing to some liberals and progressives trying to take on the Trump administration and its excessive assertions of presidential authority. And so the fact that there's no logical connection between those two, I think explains why you do see in some of the complaints that have been brought some major questions, doctrine challenges, for example. That argument has been raised in challenges to the Trump administration funding cutoffs, and it's also been raised in this case by a conservative group, the New Civil Liberties Alliance, in its challenge to Trump's China tariffs. You can make if you just focus on the logic, you can see why a major questions doctrine argument that refusing to pay trillions of dollars that have been in the first OMB funding cutoff that have been appropriated is both economically pretty big deal, politically pretty big deal, and also unprecedented and novel. So it hits the buttons of what we might think of as a major questions doctrine case. All that said, I am actually skeptical that the effort to sort of take advantage of some of these arguments that the Roberts Court has developed that have this anti-administrative edge will actually bear that much fruition, particularly the major questions doctrine. Part of this is, I have to confess, probably skepticism about the major questions doctrine for many of the reasons that we've heard already today. But it's also because recognizing the ideological connection makes me think that the court is unlikely to feel much appeal to using major questions doctrine as a way of targeting Trump's actions with respect to the executive branch itself. That they may very well work when you're talking about actions out in the world to some extent, but when you're talking about structuring the executive branch itself or presidential power over personnel, I think what you see there is you're setting up a conflict between this line of anti-administrative cases and this line of presidential power cases, which have been conjoined for the court in terms of its ideology. And I'm not sure that they're going to be so receptive to using those arguments to try and attack presidential power. So I think there probably needs to be some, some care about how you structure the arguments there, and not necessarily thinking that we can easily turn some of these anti-administrative trends to a more progressive direction. Thanks.
Ken?
Thank you, and thank you all for inviting me today from the New York University Law Review and the Institute here. Thank you all for letting me have some time to not only talk about these ideas, but to see so many of my good friends again and to meet new friends here too, that we all share this same concern about our moment today and where we are in administrative law. And what I would like to do is turn to Loper-Bright, but talk about something much bigger than I think any question of judicial deferences, and that really is the rule of law and consistency. And I want to start in a place where my mind went when Loper-Bright was decided for some reason. I recalled back to 2010, and there was the BP giant oil spill, the Deepwater Horizon oil spill in what is now the formerly Gulf of Mexico. And during that time, there was a, now not Twitter account, but a Twitter account, that was a parody account of BP. And it was supposed to be from BP's marketing team. And it said, "Catastrophe is such a strong word. Let's just agree to call it a whoopsie-daisy" in there. And I thought, what is Loper-Bright? Is it a catastrophe or is it a whoopsie-daisy? What is it? What was Chevron? Was Chevron a catastrophe or was it a whoopsie-daisy? And my answer may surprise you a bit. As many of you may know, I filed an amicus brief with Professor Walker to support Chevron. But the court's decision to end Chevron, to me, Chevron itself may have been a whoopsie-daisy. As we heard earlier, Chevron wasn't perfect. There were issues with it, even if I thought the arguments on balance were stronger in favor of keeping Chevron. And many of the reasons just because it had been around for 40 years, there were reliance interests tied to it, and there hadn't been a legislative response to it. Part of the reason I feel this way is because of comparative work that I have done before, where you can look at numerous other countries that have essentially gone through this exact same issue that we have gone through. Germany has gone through it. Canada just recently got rid of its Chevron deference and turned back from it after looking at earlier decisions coming out of the Supreme Court. Australia got rid of it some time ago. Italy can't decide what it's doing from week to week, essentially, on deference. They're still democracies. Do I think we're going to end the rule of law by whether we have Chevron deference or not? I don't. I don't think it's that significant. And if anything, given how much we're going back between this push and pull on deference, I think we missed a real opportunity as administrative law scholars. We should not be calling it Loper-Bright. We should be calling it by its companion case name, Relentless, because that's what's going to happen. We are going to be relentlessly going push and pull between how much deference we want, how much political insight or activity we want. That's Chevron. Well, what about Loper-Bright? Unfortunately, I think Loper-Bright was a catastrophe. And again, it's not because it simply overruled Chevron. It's because of how it dealt with stare decisis. So to understand that point, one has to go back to an earlier case decided 5 years before, that many of you know, Kaiser, which concerned our deference. And the key thing there is the court upheld our deference, which is deference to an agency's interpretation of its own regulation. I feel confident that if we polled the scholars here today, they would tell you that at the time, certainly, Chevron was not nearly as controversial as our deference was. And really, the thinking went, if our deference survived, then you would think Chevron deference would survive. What is more important, though, to that discussion is in the majority portion of the opinion, and there were plurality components of it too, there was a portion on how to think about stare decisis specifically in the context of judicial deference doctrines to administrative agencies. That portion of the decision, again, was the majority opinion, joined by 5 members of the court, including the Chief Justice, who 5 years later would write Loper-Bright. The court required, quote, an unusually special justification for overturning our deference. And the reasons that made it especially difficult all apply to Chevron itself. Yet the court did not discuss any of these arguments when it was discussing the stare decisis question in Chevron. So first, it said in Kaiser, that there was a long line of precedents where the court had relied upon the decision dozens of times and the lower courts thousands of times. The Supreme Court and lower courts relied upon Chevron even more than 70 times, and thousands of times in the lower courts. Moreover, the court had numerous decisions that built upon Chevron, including Meade and King v. Burwell, to name but 2. The Kaiser court's statement that deference to reasonable agency interpretations of ambiguous rules pervades the entire corpus of administrative law applied just as much to Chevron. Second, the court stated that overruling our would unsettle numerous settled constructions of rules. Now, the Loper-Bright court did deal with this concern by saying that all decisions relying upon Chevron were entitled to stare decisis effect. But given the court's expansive understanding of the general statute of limitations under corner post that it also decided that same term, that applies to those challenges brought under the APA, that seems to undermine the entire rationale the court just gave that we are simply going to keep on keeping on with anything that had been decided under Chevron. Those regulations and their interpretations, the judicial constructions, are now all up for grabs potentially based on which statute of limitation applies. Moreover, the same rationale that Loper-Bright used would have applied just as well to Kaiser, which also could have overturned our deference and said we're going to keep on keeping on with the earlier decisions that considered these regulations. Third, Kaiser said that Congress could always change the nature of deference because our deference was not a constitutional rule. Because Congress had not done so, especially in light of the justice's skepticism over the doctrine, and especially in light of the court's clarification that deference doctrines were rooted in the APA, the court, quote, would need particularly special justification for reversing our. Chevron, of course, was more of the same. Congress had not reversed Chevron, which was understood as an interpretation of the APA, despite questions from the justices in fewer than the past 10 years. Instead, in 2 brief sentences, the court said that there was, quote, no reason to wait helplessly for Congress to correct our mistake, and then listed decisions where it had overturned its own statutory precedents. The court did not refer to the many times that Congress had refused to enact proposed legislation to overturn Chevron, or the identified times that it had accepted and actually relied upon it. Indeed, one wing of administrative law scholarship, and one we were talking about a bit earlier, and it tends to be the wing, not always, but tends to be the wing that's tied closely to the fear and loathing of Chevron, is the one that says the courts need to start treating Congress like an adult and not fix all of its problems. But what did this court in Loper do? It clarified that really Congress is just helpless here. There's nothing it can do. We have to come to its aid. Perhaps the Kaiser discussion of precedents was badly reasoned, but the court did not directly address them. Instead, it seemed to go out of its way to ensure that all parties think that the court's membership, not any particular rule of law, guides the decision. For folks like me, who believe law is something different than personality and that it's constraining, Loper-Bright was a catastrophe, even if Chevron itself might have been that whoopsie-daisy. Now, that's not to say that Loper-Bright said nothing about stare decisis. It does, even if it fails to acknowledge the more on-point arguments that it had made in this context 5 years previously. It pointed to the following. First, the court's failure to discuss how Chevron fits within the APA section 706 rendered Chevron, the court said, without staying power. Given that Kaiser did not do so either, it's not clear why it matters in Chevron, but did for our. The best argument is our deference was established shortly before the APA's enactment and was incorporated, whereas the pre-APA Chevron-looking cases, as concerned mixed fact questions, or at least were characterized that way, and therefore there's some distinction between the two. But for a court that was so concerned with congressional intent in the APA, it's striking that it failed to consider the evidence that was contrary to its conclusion, or consider how the same APA could not permit deference for agency legal interpretations of a statute, but could permit deference for agency legal interpretations of a regulation. It's the exact same provision. For a textualist court that was also relying on textualism, or the lack thereof, for stare decisis considerations, I would expect much more extended analysis. Second, the court found Chevron unworkable. The main objection is that ambiguity is difficult to define. Well, tell it to our deference. It also uses ambiguity as a trigger. Or better yet, for centuries, go tell it to contract law, where we allow judges to identify ambiguity. And then what do? We hand it over to a jury for the jury to resolve the ambiguity. Courts know how to identify ambiguity. It's something we've been doing for some time. Finally, and perhaps most compellingly, Chevron does not promote reliance interest, given the uncertainty of the doctrine's application and its ability to allow agencies to change from one reasonable interpretation to another. This strikes me as a fairly legitimate basis for finding a doctrine less legitimate and less suitable for stare decisis treatment, because unpredictable law has reduced normative force. But even then, it's odd how the court's our precedent had already addressed this concern by disallowing deference for inconsistent interpretations. Had the court even acknowledged its prior precedent on precedent, the reliance-based discussion perhaps would have been enough, in my mind, to justify Chevron's end, even if it may not have been my preference, and even if it came from a court that has destabilized numerous areas of law in a short time frame. The plea to reliance certainly rings hollow. Loper-Bright could have simply fixed this doctrinal error, but in failing to address the most on point and extremely recent precedent, it's dispiriting to the many of us who think that numerous legal issues are difficult, want to believe in the good faith of judges, and want to have law not flip between one legal fad to the other. For many, Loper-Bright was a victory, but for others of us, whatever the specifics of Chevron, Loper-Bright was that catastrophe, leading to a troubling future for how exactly we think about stare decisis, how we think about the rule of law.
Thank you. Sure.
Great. I also want to start by thanking the Law Review and the Institute for including me here today. And I'm so curious about when you guys named this conference where administrative law goes from here, if you had imagined that the definition of here was going to change on, I don't know, a daily and hourly basis, but it feels really good to be in this room with so many people that I admire and respect in the midst of these really sort of head-spinning times. So I'm really grateful to be here. And what I want to do with my short opening remarks is to focus on how recent developments will affect the labor movement and working class people, and then link that to the bigger challenge that we're facing in terms of the assault on the rule of law and the very institution of democracy in our country, which I know it's late in the day, so I'm going to be a little salty here. I think you cannot in this moment separate these trends in administrative law from what we have seen over the past 80 some odd days. I think I share Jillian's skepticism that these doctrinal shifts are going to play out going forward in the same way that they played out during the Biden and to some extent during the Obama administration. And in fact, I would argue that these doctrines, and I'll talk about this a little bit more in a minute, have actually given rise to some of the most extreme behavior, or some, there's been a lot of it, that we've seen over the past couple of months. Okay, but I'm going to just start with sort of straight up, what does this mean for the labor movement and for working class people, which has been most of the focus of my work over the course of my career. So starting with the impact on the National Labor Relations Act of Loper-Bright, I would posit and have written that I don't think that Loper-Bright should have a big impact on how the courts view the NLRB's interpretation of the act. Well, why not? First, because it's been such a long time since the board even tried to get away with relying on Chevron deference to support its decision-making. Second, the court's citation to Hearst and Loper-Bright as an example of a case in which Congress had empowered an agency to decide how to apply a broad statutory term that applies to specific facts found by the agency seems like a good sign that the court isn't going to bring a completely skeptical eye to NLRB decisions. Some of us long-suffering labor law lawyers believe that there are special rules for the NLRB in the Supreme Court and that they are always skeptical, but maybe that citation should give some hope. More importantly, the court's concession in Loper-Bright that the best reading of a statute may be that Congress intended to grant discretionary authority to an agency to interpret a statute should bode well for much of the board's precedents. Again, the court includes in this section of the opinion a cite to a board case. I take that to mean that the court believes that Congress has in fact delegated to the NLRB at least some discretionary authority. And the court's treatment of the board's authority before Chevron supports my cautious optimism. For example, in Ford Motor Company versus NLRB, a case decided 5 years before Chevron, the court held that if the NLRB's construction of the statute is reasonably defensible, it should not be rejected merely because the courts might prefer another view of the statute. The court based this holding on its conclusion that it is evident that Congress made a conscious decision to continue its delegation to the board of the primary responsibility of marking out the scope of the statutory language. Great, so maybe Loper-Bright is a whoopsie in terms of the NLRB. All right, but lest you mistake me for an optimist during these dark times, let me now share why, although I believe everything I just said, I also believe that recent developments in administrative law pose actually an existential threat to the labor movement and to the ability of working class people to have their interests weighed in decisions that our government makes. So why am I ultimately so pessimistic despite my doctrinal analysis of Loper-Bright? Let's start with the fact that not a single member of the Ford Motor Company court still sits on the bench, and the justices who do sit on the bench, as I just mentioned, seem to have a deep antipathy for the NLRA, for the authority of the board, and the decisions that it makes. Second, we still have to contend with the potential impact of major questions doctrine on interpretations of the NLRA, and I would add also the Fair Labor Standards Act, which is by many considered to be sort of the crown jewel of the undergirding of some basic economic security for workers in this country. So if we look at the impact of major questions on those two statutes, we have to look at the factor of political significance as a qualification for application of major questions doctrine. It seems then that it's almost automatic that any decision of the NLRB, certainly, and maybe decisions regarding interpretations of the Fair Labor Standards Act, are going to trigger major questions doctrine because of the way that the political salience of the issues that come up under those statutes has really been amped up and is often right at the front line of many of our deep political disputes in this country. And so with the ability of parties to sort of generate political rancor on almost every aspect of labor law and of economic justice, I think we'll see, and we have seen, that major questions doctrine plays a very large role in interpretations of those statutes. And we are seeing parties relentlessly challenging NLRB decisions, Department of Labor regulations, Fair Labor Standards Act, based on Loper-Bright and major questions doctrine, even when those arguments are particularly thin. And again, coming back to major questions doctrine and even Loper-Bright, you have, because of the political nature of these issues, you have very old statutes, right? These are New Deal statutes, and an almost inability of Congress to even contemplate updating those statutes because of like the political peril of even opening those doors. So you have, I mean, the likelihood that you could have consistent interpretations of these statutes, as you imagine how the American economy has shifted, that you could have consistent interpretations of the statutes over that period of time and have them still do the work that Congress intended them to do, I think makes them particularly vulnerable to Loper-Bright and major questions doctrine challenges. In the interest of time, I won't even get into all the other challenges, especially to the board, particularly coming out of the Fifth Circuit's decision in Jarchese, where it is a fact right now that basically workers in the Fifth Circuit or who work for companies that can manufacture venue in the Fifth Circuit, even if we could get past the problem of the lack of a quorum for the NLRB, do not have a right to collective bargaining anymore simply because of the Fifth Circuit's Jarchese decision. And we're seeing that decision impact cases that have been given rise in New York and different places where through administrative law shenanigans, those really core rights have broken down. So I think overall this paints a pretty grim picture of how administrative law is impacting the right to collective bargaining. And that's even before we get to the most recent events and what at least I find the incredibly shocking executive order issued by the Trump administration earlier this week. I don't think it's particularly actually provocative to say that this EO is a dangerously lawless exercise of power and potentially highly consequential. Its impact on the National Labor Relations Board's decisions might not be clear yet, but we are seeing different trade groups weighing in with the administration with very long lists, dozens of board decisions that they would like to see on this list of automatically repealed agency decisions. Maybe they'll surprise us, I don't know, but they're also adding to these lists probably, I don't know, every regulation I've ever worked on in 8 years of the Obama administration and into the Biden administration, laws that protect the safety, the health, and the livelihoods of working people. And I think it's fair to say this executive order was at best facilitated by both the court's doctrinal shifts and its barely suppressed hostility towards, or sometimes blatant hostility towards the administrative state. I think at worst you could say that the court's administrative law jurisprudence recently actually invited this kind of executive order. We'll have a better picture of what's at stake once we see the actual lists of regulations that will be repealed in this automatic fashion. But I think it is going to be very heavy on rules that the labor movement and working class people rely on to be safe and to be treated fairly in our economy. And just to sort of just to pull it all together, I mean, even if the board's decisions, for whatever reason, are not prominent on this list of repealed regs, the harder that this administration's efforts through the exploitation of these doctrine make it for working people to be able to earn a living, the less likely they are to be able to engage with our democracy, particularly through organizing a union. And I know this isn't a labor law conference, so I won't give you my spiel on why the labor movement is integral to preserving democracy. You have to trust me on that one. what it really is. And I think that, I should have asked the history panel that. But the debilitation of the National Labor Relations Board, of these basic labor standards protections, I think are making it clear that administrative law is the playing field on which our democracy will actually be won or lost.
Hi, everyone. I want to add my thanks to Don and the Policy Integrity Institute, the NYU Law Review, and to David for organizing, and also to thank all of you. You made it. The very last panel and the very last speaker. So thank you so much for continuing to listen and engage. For a while now, I have been interested in how administrative discretion operates. And so for perhaps too long, I have been looking at guidances and manuals to sort of figure out what the exercise of discretion looks like on the ground level, on the front lines. And part of that work has involved grappling with the sort of immense and far-reaching political control that is exercised over ground-level administrative processes, including informal adjudication and enforcement, and with the politicization of administrative discretion more broadly. And so I'll start with an observation, possibly a provocation, I don't know. There's no such thing as an insulated exercise of administrative discretion anymore, okay? In certain agencies, including those in environmental protection and public health, labor, et cetera, the ones that have been primarily the focus of today's conference, the current administration is firing folks who might be interested in making policy on the basis of scientific or nonpartisan expertise. In other agencies, like in national security, immigration, enforcement, the bureaucracy acts primarily with a politicized aim, or at least under significant political pressure. And so in these brief remarks, let me see my time, okay, I will discuss the politicization of agency discretion in the immigration context. There's a lot to unpack here. I am still working on it, admittedly, but let me set the stage to the best of my ability. Okay, so we know that recent Supreme Court cases like Arthrex and Lucia, the Fifth Circuit decision in Jarkissi, have expanded article to appointment power and removal power to ensure that the president and political appointees have as much control over administrative law judges as possible, right? This is based on a view of political accountability as important to maintaining accountability in the administrative state. And then we have those in the opposing camp that believe that this form of political influence will compromise decisional independence in administrative adjudication, and this independence is understood to maintain high quality and unbiased decision-making. And this perspective views administrative adjudication and ALJs as made accountable not by politics, but by procedure, particularly as governed by the APA. Okay, so intro to ad law right there for a minute. However, both of these positions, while they are in contrast or in tension with each other, are also united in important ways. First, both of these assume the existence of and in fact espouse a large system of formal administrative adjudication as defined by the APA. Both positions assume that the primary mechanism for political control over agency adjudication is through appointments and removal of administrative law judges. And so as a result, for better or for worse, this debate overlooks the large swath of administrative decision-making that is neither conditioned by transparent appointments requirements, nor anchored by the procedural floor established by the APA. And immigration is a great example of this no man's land. It's not the only one, but I only have time to go into one, so that's the one I'm choosing. Because immigration adjudication and enforcement decisions are not bound by the APA, the process underlying these decisions can vary widely, from split-second enforcement choices to paper-based adjudication, in addition to the immigration court proceedings you may have heard a bit about. And the political control exercised over officials in the immigration bureaucracy is both opaque and can be sort of unrelenting, as opposed to the kind of, as opposed to only related to appointment or removal decisions. And it is also completely unconstrained by the APA. So for instance, when a person brings an immigration case, her procedure may differ depending on the immigration judge's interest, possibly in deciding the case as quickly as possible, as required by higher ups, or based in the pressure exerted by the Department of Homeland Security, if you're talking about a decision made in that agency. And so in effect, there's a lot of political and even presidential control over administrative discretion in immigration. There is a distinction to some extent between how informal adjudication and punishment enforcement works, but both involve a fair amount of decision-making by bureaucrats with discretion for the purposes of my points. And the locus of discretion has moved from the agency or the adjudicator or the enforcement official to the political higher-ups. And so this is sort of a different story from the one of immigration judge or ICE enforcer, run amok due to their own bias or violent tendencies, okay? All of this suggests that administrative enforcement and informal adjudication are an understudied mechanism for the politicization of agency action. And, at least in this context, this politicization may reduce the quality of or access to administrative process as a result. Okay, so for better or for worse, this dynamic has been at the forefront of the recent news cycle. Three weeks ago, the federal government started sending scores of Venezuelan immigrants detained in the US to a foreign prison in El Salvador. It did so without any due process, under the auspices of the Alien Enemies Act, a 1798 law designed for times of war. I'm quoting Sotomayor, by the way, in my description of what happened. And concurrently, my own description, the administration also mistakenly deported a Maryland man to a horrific high-security prison in El Salvador, which the White House itself admitted was the result of an administrative error. And note, this could happen to you, even if you are a citizen. The GAO found that ICE arrested over 650 US citizens, detained 150 or so, and deported maybe 70 potential US citizens in the 5 years between 2015 and 2020. Okay, so around the time all of this started happening, I started getting some phone calls and such asking me, from some colleagues in ad law and maybe even outside of our spaces, is it true that there is no recourse for someone mistakenly deported? And I shared what immigration advocates have known for some time, that immigration decisions can happen without adequate or any procedure. In other words, this might be a flashpoint, but it is not a completely sort of different set of frameworks. It is the intensification of a set of frameworks that have existed for some time. Okay, so let me give you a couple of examples briefly, and then tell you why I think all of this matters. First, informal adjudication, including of immigration benefits and access to immigration, can be shaped by presidential aims or dictated by the White House. I'll talk in particular about the politicization that happens in what's called the US Citizenship and Immigration Services, which is housed in the Department of Homeland Security. This subcomponent has the authority to grant a variety of immigration benefits, including regarding humanitarian parole, asylum, work authorization, and the sort of guidance shaping this agency is the USCIS policy manual. Now, since 9/11, many of these decisions are made under the shadow of potential threats to national security. But furthermore, under the first Trump administration, and sustained throughout the Biden administration, by the way, USCIS was granted the authority to exercise discretion to deny benefits regardless of applicants' eligibility and without any justification at all. So the policy manual itself states it is legally permissible to deny an application as a matter of discretion without determining whether the requester is otherwise eligible for benefit. Discretion has always been part of the agency's decision-making, but this guidance really places new emphasis on the ability of officers to deny a benefit, even when an applicant meets the statutory requirements. Okay. Political pressure also impacts how immigration punishment is enforced. This has long been the case. Sometimes it can lead to, political oversight can actually lead to prosecutorial discretion. You may have heard of the Deferred Action for Childhood Arrivals program under the Obama administration, which deferred deportation for certain children who had been brought to the US, who had graduated when they were young, a certain number of years ago, who had graduated from high school or earned a GED or served in the military. But in recent months, we've seen immigration enforcement priorities take a different turn, right? Rather than determining who might be spared from deportation based on favorable qualities, the emphasis has turned to focusing on criminality for deportation. But the procedure for determining who is a criminal is opaque and inconsistent at best, maybe non-existent at worst. And so the administration has, in some cases, seemed to be targeting students they view to some degree as a threat. So many of us may be familiar with students on our campuses who have been picked up by ICE. And in doing so, they are using many more resources than are generally used to detain individual non-citizens. And compared to the DACA program, there is no notice or information regarding what qualifies someone for this more intense form of enforcement. in addition to the fact that many of the targets are legal permanent residents or are here with valid documentation. Okay, so besides the sort of granular, humanitarian aspects of this, why is this interesting, maybe for the purposes of administrative law more generally? Well, the responsiveness of immigration discretion to political interests may very well appeal to those who advocate for presidential adjudication or strong presidential control over agency adjudicators like the Roberts Court. But political influence dilutes the impact of fairness, expertise, or other values on agency discretion and decision-making, even outside the confines of formal adjudication. So in other words, as I said, political influence appears to reduce access to process. And arguably, it disrupts both formal, loosely conservative, and functional, loosely liberal visions of executive power as well. And in some ways, what I'm about to say connects to your remarks at the top of the panel. On the one hand, those in favor of the unitary executive theory, including the current court, are also committed to dismantling the administrative state, which is viewed as oppositional to the president's interests. Perhaps that's the connection between the two sets of doctrine. But to the extent administrative discretion is a vehicle for presidentialism, curbing agency autonomy, in fact, constrains presidential power, for better or for worse. So the analogy here is to the idea that constraining capacity, administrative capacity, can actually harm a president's interests. Here, we see a president harnessing administrative discretion to build a more unitary executive. Okay. On the other hand, this means that expanding administrative discretion does not insulate administrators from political influence. And so many liberals are concerned about the Loper-Bright decision and would prefer to expand administrative discretion and authority in many ways. This camp argues that internal administrative law, I can't help but gesture to my colleague next to me, primarily procedures required, who has pioneered some of this work, primarily procedures required by the APA, like notice and comment rulemaking and formal adjudication, legitimize an expansive and powerful administrative state. In fact, there is some talk about proceduralism, not only a fail-safe, but even a fetish, right? That it has come to hamstring what agencies are doing. There have been progressive calls to establish systems of public rights and entitlements with only minimal constraints on bureaucratic discretion. There are progressive, anti-juristocratic calls to eradicate the Supreme Court, transfer adjudication to the agencies based on the assumption that the administrative state is a more reliable site for statutory interpretation than the judiciary. And yet, the politicization of discretion at this level undercuts the stability and consistency of proceduralism, particularly for those many, many actions that fall outside the APA's auspices. Enforcement and informal adjudication are also relatively untouched by intra-agency appeals and judicial review. In many instances, the final results of informal administrative adjudication that is impacted by political interests may be appealed, but discretionary choices to change the process are not. And then in other cases, the outcomes of these decisions may be unreviewable as well. And so this brings me to a decision from earlier this week, Trump versus JGG, which said that people who are detained and deported under the Alien Enemies Act have no recourse under the APA. And so the court says that challenges, quote, challenges to removal under this statute, a statute which largely precludes judicial review, must be brought in habeas. And Justice Kavanaugh's concurrence makes the point clear. The question turns on whether these transfer claims belong in habeas corpus proceedings or instead may be brought under the Administrative Procedure Act. I agree with the court's analysis that the claims must be brought in habeas. This is a form of review, but not administrative review, administrative law review, as should perhaps apply to immigration, which is an area of administrative law. And so the dissent laments. Per Justice Sotomayor, habeas is the wrong tool. The plaintiffs in this case sued not to challenge their detention, but to protect themselves from summary deportation. She notes individuals who are unable to secure counsel or who cannot timely appeal an adverse judgment rendered by a habeas court face the prospect of removal directly into the perilous conditions of El Salvador's high-security prison, where detainees suffer egregious human rights abuses. And then per Justice Jackson's dissent, I lament that the court appears to have embarked on a new era of procedural variability, and it has done so in such a casual, inequitable, and in my view, inappropriate manner. Okay, so just to wrap this up, a few words about the relationship between the executive and the judiciary that we might, what we might take from this on that front. The court has certainly taken an anti-administrativist turn. There have been worries about a possible separation of powers crisis if the executive branch does not comply with judicial orders. And I think this is particularly amplified in the immigration space. However, also in the immigration space, we see a judicial willingness to acquiesce to the aggrandizement of administrative enforcement power, and in turn, implicit support for consolidating presidential power. And then finally, it bears noting this politicization of agency discretion does seem to cut against the interests of politically and economically disfavored people, such as non-citizens deported under laws leveraged by the president, like the Alien Enemies Act. The administration is likely to detain non-citizens in jurisdictions that are more favorable to the administration's goals, rather than the DC Circuit had a form of administrative review been available. Marginalized communities won't have the political power to fight these detentions as a collective, nor to sway them from the top down. I doubt either party will make an effort to safeguard the procedural interests of this community, since neither party benefits from this community as a voting bloc. So what might we do about it? I have a whole set of blue sky, idealized thoughts, which I will save for Q&A in the interest of time, so thank you.
So first, before we get to questions, I am told I should repeat the CLE code, which is, at this point, relentless. And I am now told that I should spell it, though you could Google the case. RELENTLESS. And I have now fulfilled my duty. So I'd love to push all of you on the degree to which the doctrinal developments really cut in a single substantive direction, or if not single overwhelming substantive direction in terms of who ideologically or in terms of economic power is benefited. And to take the view for a moment in the question of things change over time, maybe we can't predict so easily. According to some, there's been a long history in administrative law of certain developments then cutting against those who originally developed them. Some theory of the APA was that the Democrats agreed to it in order to lock in the New Deal against a new potential Republican president, but Truman won. Obviously a story of Chevron, in which a court grants deference to a Reagan administration, Chevron obviously being in the case name, and is initially embraced by conservatives as a way of allowing potentially a presidentially led conservative administration to have room to run with a more liberal judiciary. So, focusing now, for a moment on Chevron and Loper Bright, will the court now, with a new, whatever you want to call Trump conservative or whatever he is, president, rue the day as they will be pushed to give him room to run, and all of the litigants against the Trump administration will be citing Loper Bright up and down, since Skidmore, they're flipping position and so on. So will it in fact cut against, or does it really overall cut towards one ideological position?
I'm happy to at least start. I think it does cut towards one ideological position, despite the sort of historical anomaly of the genesis of Chevron, because it goes to the ideological difference between those who believe in the necessity of a robust role for the government in ensuring that we have basic protections, that we have a fair system, and those who want to constrain or believe philosophically in a more constrained executive branch. Now you may say, but look at what we've gone through over the last 80 days. That's looking like a lot of executive activity, but it's really in a pretty narrow range. And I think they're very aware of the potential that these doctrines may cut against them. And I think that's why we're seeing so much of what they do justified on the basis of national security or foreign relations where they think that these doctrines will have less purchase in the courts. And I think that also has an ideological valence. But it's too early, obviously, to see, but to the extent that we see over and over again in the court's decisions around constraining the administrative state, the fears of the coercive power of the state, I'm very concerned that we're going to see in decisions that address what the Trump administration will characterize as deregulatory actions, a different response.
So, do you want to go? Go right ahead.
Sure. Yeah, I don't think the current administration will care. So the Chevron decision, right, was a version of statutory interpretation that was put forth to kind of support Ann Gorsuch's view of deregulatory EPA. But the Trump administration's approach to deregulation is not through the prism of statutory interpretation, right? It's just through the sort of like direct dismantling of the administrative state's resources and personnel. So they have many more sort of pathways to accomplishing their goals than just the one that might be barred by Chevron, for what that's worth. But that really wasn't, I was going to say something about immigration, I guess, which I can say too. I think that's where there's a little bit of actually, I can point to Chris, who wrote an interesting paper some time ago. Actually, conservatives and immigration advocates make interesting bedfellows when it comes to Chevron, because some of immigration advocates have been concerned about administrative interpretations of immigration law and enforcement, and have wanted to see more judicial review and constraint of agencies. And so unlike the public health and safety spaces where a lack of deference means a lack of opportunity to regulate further, here a lack of deference could translate to limitations in enforcement power. But I don't actually think that's what's going to happen either. Loper-Bright carves out a fair amount for agency discretion, and I think there are many ways in which the court will continue to defer to agencies' shows of power, illustrations or kind of exercise of strong discretion in the immigration and national security contexts for various reasons that Loper-Bright won't be able to touch.
So I'm similarly skeptical that it makes much difference to the Trump administration. Some of what they're doing is so clearly at odds with law that it doesn't seem to matter if you put it with a possibility of any deference or you put it just straight up independent judgment. Either way, it's going to just fail, but they don't seem to care. I do think that when you take the question of the payout of Loper-Bright and the move from Chevron, it's helpful to take just a step back and think about the broader political context. Chevron became a progressive tool in the world of a Congress that cannot enact new statutes, and that we have deep political divides and very competitive divisions in Congress. So you turn to the executive branch because you can't get things passed through Congress. I don't see that dynamic changing. So as long as that dynamic is there, I tend to think that Chevron and deference are going to be more important to progressives than Loper-Bright independent judgment as a curb on conservatives. The other factor that I think you have to take into account is who's implementing these doctrines. And there, we are seeing there is some variation. There are some courts that are very conservative. There are some courts that are less so. But what we saw under the Biden administration was that it was incredibly easy to go into the courts that are conservative and bring suits that would bring down and stop legislative action. And that was in many ways before Loper-Bright was even adopted. So I don't know that Loper-Bright and Chevron is really going to be the kicker there. I just am very skeptical that we wouldn't, that any chance you can get for a little bit more deference, at least in the regulatory space. And the third point is, I think that that's in part going back to something that actually Chris said, which is what's your default, right? And if your default is sort of the way things are operating or the way things have been or regulation as it exists, and what you want is to have power to address a new threat or a new problem and be more pro-regulatory, that's going to mean that you need more authority. And so I think what we have seen is it has played out in that direction. I'm not saying it's a logical necessity. I can certainly see how one would think you'd want less discretion for the Trump administration. I just think in general, it's something that's going to be playing out where progressives will lose more than they will gain.
I'll just add something, maybe over the longer term. What I think makes administrative law so hard is you constantly have to think about, how is this going to work for my team, and then how's it going to work for the other team when they're in power? And that can make it really difficult to figure out what is the preferred rule. And you can see how alignments shift. I mean, if you take Chevron itself, Chevron arises from Justice Scalia. He has a speech where he straight out says, what Republicans have to remember is they're our bureaucrats now. When Reagan came into office, he's thinking about ways, how do we, Republicans, get more power as opposed to a DC circuit that had all essentially liberals at the time? Who should be making the decisions? Well, in that moment, in 1984, it made more sense for that coalition to have Chevron, where deference is to the political party, the one in the executive branch. Well, you can see how that shifts over time. Right now, it's Republicans who control the courts. They also happen to control the political branches right now. What happens as time continues on and we see these shifts go? I expect some musical chairs to occur with this and how people think about deference going forward. I think the key really is consistency. I think one test we will see is how courts think about reliance interests and accounting for them. The Supreme Court, for now decades, has really leaned into the notion of we have to care about reliance interest when we are changing regulatory regimes, when there is some kind of flip-flopping that's occurring. Well, there's a whole lot of that going on right now. But I don't really see that showing up in the briefs. I don't hear people talking about the reliance interest and asking what kind of discussion did the agency give when moving from one thing to the other thing. I think the proof is going to be in the pudding here on how consistent the Supreme Court is in taking its doctrine and applying it to other areas. And I'll end with this to the point that one doctrine may start with one party in favor and move to another. I'll give one example, and this is why I think it takes decades to figure out what's going to happen. I think about due process. There's a kind of a leading dissent that Justice Marshall, Thurgood Marshall, had in the 1980s, where he takes a very broad view of due process, and he essentially says, whenever the government is not giving you something that you want, you are entitled to process. It's very broad for it. And when I was clerking, we had a procedural due process case, and one of my co-clerks was quite conservative, and I was telling him about this, and he said, oh, I love Marshall's dissent. And I was like, you do? I mean, it was a little surprising, because Marshall was thinking of like protecting the downtrodden who the government was acting upon. And I said, well, why is that? And he said, well, if the government has to give process on everything, it can't do anything, and that's exactly what I want. I think we all have to be very careful. Again, what rule do we really want, and how in 30, 40, 50 years' time might that play out when it's not in our hands and when the political dynamics have shifted?
So, jumping off a number of the comments there, I want to push on especially the characterization. Obviously, we're in a present moment, and there's a question of how do we characterize what the Trump administration is attempting? One characterization is deregulatory. Another characterization might be not deregulatory, maybe in certain areas, but of tremendous government power and government interference with the private sector in a way that is certainly different than what the opposing party would do, but is actually maybe even more forceful. And so that then brings me to the questions around non-delegation, major questions doctrine. And again, there, the valence has generally been it's against liberal, progressive interests in trying to regulate big. But does Biden v. Nebraska stand for a Democrat can't forgive student aid, or does it stand for that Congress has not delegated that much fiscal authority and therefore impoundment will be ruled not to be a presidential power? Does West Virginia v. EPA stand for you can't regulate climate, or does it stand for you can't try to shift the economy in that way without an explicit delegation like they were trying to do with tariffs? How should we see these developments, especially when the disagreement among the parties may be, at this point, less the robustness of government activity, but instead the nature of it and the direction of it?
Maybe I'll just go quick, because I've already stated sort of on major question doctrine, I'm pretty skeptical that,
Yeah.
the courts are going to use that as a way to get at presidential empowerment. I think the thing that I would emphasize about 2 points. One is, I think there are more standard and available constitutional arguments and statutory arguments to make against presidential impoundment. I don't think you need to turn to major questions doctrine. And I think the more we can bring it, strictly within it is, both clearly a congressional power, if you want to go constitutional, and also at odds with many appropriation statutes, although not all. I mean, you have some discretionary appropriation statutes, in which case you're going to have to acknowledge then you've got discretion in the executive branch, and that may be an area of some presidential power. But in terms of the sort of wide-scale, let's hack trillions of dollars here and there kinds of moves that they're making, I don't think you need to turn to major questions or non-delegation. And as I've indicated, I think those are, I think you'd be inventing non-delegation, and I don't see why we would do that now. But I also just think that will only, in my view, would only backfire on those who want to preserve a role for effective government in various ways. So I'm very skeptical about that one.
And
Oh, actually, can I just remember my
Yeah.
second? My second point is, I think your question really highlights the importance of different areas, right? So what is happening right now is empowering in immigration, right? There's been a tremendous expansion of authority there. And then there are other areas where it's just been slicing away basic capacity to be able to administer programs that, like, look at what's happened to Social Security Administration, right? So I think it highlights the fact that I don't think there's a single message across the administration on those fronts.
So now to move on to a question from the audience. So given the developments all of you have discussed, and reminds me of Kent of your comments on stare decisis or lack thereof, this questioner says, I will ask the question my students ask, what does it mean to teach this stuff as law? Which feels like it used to be only appropriate at an international law conference, but has now potentially become, sorry to my colleagues, but it has become more, maybe more appropriate here. So how does one answer that question?
I mean, I am teaching admin this semester, so it's really hard. I don't know how many people out there are teaching admin this semester. Like, it's a challenge, and I find it, I'm as much a psychologist in the classroom as I am a law professor, in that I find my students are really struggling to figure out what this all means in terms of how they have chosen to pursue their careers. Like, does it even, a week doesn't go by where I don't have a student come to me and say, why am I doing this? Why am I here? I've chosen to deal with it sort of head on. We talk about what's going on, but they are so, I mean, I think this is an inclination for law students anyway. They so want to know, what is the new test? Like, how does this fit with 3 parts that we read in whatever case? And I don't lie to them. I'm like, I'm not going to give you a 3-part test. Here are things that you can bring to analyze. We talk about, like, January 19th. We will say, okay, we're doing this. This is a January 19th discussion. And then we'll talk about January 20th on, so they can see, like, how things may be shifting. But I find it to be just really, like, I mean, I'm not whining about myself. Obviously, this is, like, what's happening is really challenging in profound ways for so many people. But I do find it incredibly, like, emotionally draining, because they feel so destabilized by this moment, particularly in admin.
I have a thought that connects to this idea of transsubstantivity in administrative law, which, by the way, I do think is a bit overstated, in that people who work in various areas of administrative law are highly aware of the ways in which their regulatory areas differ. But I do think that it is the case that we teach administrative law from a very substantive perspective, and we are heavily anchored in the APA, I think for understandable reasons, and we just kind of hand wave away the informal adjudication piece of what agencies do, which is most of what they do, and then hope students kind of didn't notice that we did that, because, and I understand all the reasons for it, but I think one thing we might take from this moment are the ways in which various areas where administrative law is practiced actually provide insight into how administrative law operates in ways that we can maybe bring into our teaching right now. And that's always been the case in environmental, labor, and immigration. To some extent, it's probably not heavily emphasized, like the differences are actually elided in order to bring forward the principle. But I think there's more work to be done to actually work with the diversity in administrative law and bring it to the forefront in our teaching of it.
So I think I'll end with the question from the audience, which I will paraphrase as, is there any hope from Congress in solving some of the underlying dilemmas here? Now, I will say in the area I work most often, there do tend to be regular pieces of legislation, largely because we use reconciliation. And obviously, the Senate filibuster is not something that is necessarily an unmovable object. But especially in the wake of whatever happens in the current moment, and if there is any kind of post-Nixonian congressional retaking of authority, is there anything that you could imagine doing? Obviously, this connects to an earlier panel. We're not starting from scratch, but is there anything you could imagine doing of Congress in that kind of environment, if it exists, taking some form of action that actually makes progress in administrative law?
I'll say something really briefly. I do think it is possible over the next 5 to 10 years or so. And here's why. I think it's because you see a significant political realignment, especially within the Republican Party. So, if you think about Republican Party of 15 years ago, you're really thinking of one that is just pro-business, typically not thinking as much about peoples that are using several benefits programs, except maybe those with social security or so. Well, now as you're seeing that realignment, a more populist Republican Party coming through, they're going to hear about it when Social Security is not working. They're going to hear about it when housing agencies aren't following through on things. It gives me some hope that what you're going to see is a coming together of different coalitions that say, you know what, we're going to be a little bit behind the veil of ignorance of what's going to happen 10 years from whatever this moment is, and we can see where enough of our constituents are affected that we can make at least some improvements to administrative process. Now, how much? I'm not promising you a new APA or anything, but some improvements that may not be trans-substantive, but may tie in at least to certain agency actions and types of administrative law.
So I would go, I think that fixing Congress on this front requires fixing the way people view government and the extent to which they have any trust or faith in government. And that is sorely lacking. And without that, I'm not sure you generate too much political. I think you're right, Kent, that particular programs, it's very interesting watching the Medicaid dynamic play out right now. But fundamentally, I think we need to bring back a much deeper-seated feeling of faith and trust in government before we're going to get meaningful reform that would help.
Great. Well, I wanted to thank our panel.
Yeah.